Get into the legal details now. Joining me, Sarah Christoph, former prosecutor for the Southern District of New York, and Joe Moreno, former US federal prosecutor, now serving as a corporate attorney. Hello to you both. Thank you very much for coming on the programme. We're going to get into some of the detail, as I mentioned, though. But first of all, just quickly from both of you, your kind of headlines, your reactions, your top takeaways. Sarah, let's start with you.
Yeah, this decision, it really reflects what happened in oral argument. I don't think it was a huge surprise based on what we heard from the justices at oral argument. Trump's team was arguing for this very broad immunity. The prosecutor's team had a very different take on it, said that all presidents are not immune at all from criminal prosecution. And the court really ended up somewhere in the middle. They've carved a path in the middle here, saying there are certain acts that are core official acts for which a president would have absolute immunity. There's sort of other acts on the edge of official acts that for which a president has a presumption of immunity. And then there's these unofficial acts for which a president does not have immunity. So I think this all was foreshadowed at the oral arguments, not a surprise, but obviously a big win to Trump's campaign here.
OK, Joe, give us your headline thoughts.
Hi, Lewis. I agree with Sarah. Not a big surprise. This is consistent with how courts have treated civil cases since the early 1980s. So I think this is the middle ground that many of us expected. I will share one thought. The fact is that this is a somewhat fair and common sense outcome. However, I will agree with one of your recorded comments earlier in the hour that said this is not really an originalist decision. This is a court that prides itself on looking at the plain text of laws, or in this case, the Constitution. And the Constitution does not speak to immunity for presidents. So yes, they applied some separation of powers concept, and they built on the earlier case for civil trials in the Nixon v. Fitzgerald case. But I get the criticism that they kind of took this out of thin air a bit. And so I understand why now the court will come under even more criticism than it has in recent months.
Interesting. OK, Sarah, let's look at this issue of official, unofficial, and the third area you talked about as well. What are some of the challenges that you come up against trying to make these distinctions and definitions?
Yeah, it is very muddy. There's no question. I mean, there are certain acts that the court said in its decision are unquestionably official acts. There is an absolute immunity. They just can't be part of this case. But there is a huge swath of other activity that the court really punted on, as they usually do. That is really not their purview to get into that type of information, and they're going to send it back down to the lower court. The lower court's going to have to parse through all of these allegations in the indictment, all of these acts, and really figure out whether they can be the basis of a criminal prosecution here. There's a lot of work to come in the case to see what can go forward and what cannot go forward.
Okay. Joe, I want to put to you some of the dissenting voices here. Justice Sonia Sotomayor, the president is now a king above the law. What do you make of that?
It's hyperbolic. I mean, I get it. It's frustrating. And I've heard some of the sort of speculations that now the president could have people assassinated and he could do things and misuse the military. And, okay, I guess that would involve many, many other actors going along with that sort of lawlessness. But I get the frustration. Again, I mean, these are conservatives in the majority that say that they look to the plain language of the Constitution. And there's nothing in the Constitution that talks about this. And so typically in these cases, you would expect these justices to say, look, we're not here to make things up. We look at the plain language. And if you want to change it, we're not ones to change it. It goes back to the legislature or the people to do that. So, again, the fact that they kind of just, built on the earlier case from the 80s and said, we're going to go with this. I understand the dissenters' aggravation here, because this is exactly opposite of what this court sort of portrays itself as being in the majority.
Sarah, I want to put the same quote to you just to get your thoughts on it. The president is now a king above the law.
Yeah, I mean, what these various decisions showed here is the real dissent among the justices here. I mean, with the concurring opinions and the dissenting opinions, we see the very sharp lines that are drawn between the justices here, their opinions on how the court should operate, and really, the political lines drawn between the justices here. So it is significant for that reason as well.
Yeah, what can we draw from that, Joe, longer term? That people have expressed their concern, again, that this split 6-3, and the three Liberal justices were the people dissenting, and that in some way damages the credibility of the institution of the Supreme Court.
It's unfortunate. I think people should note that more than 2/3 of cases decided this term were unanimous. Those are often the ones that are not the headline grabbers, though. Look, yeah, I mean, people are going to see the justices in many of these cases deciding not on the merits of these cases or on their legal philosophies, but on who it benefits. I hope that's not the case. I think that's a perception that has been growing. And so I think that our political leaders in Washington and our members of the judiciary really need to work extra hard to make it clear that they're not here to pick winners and losers. They're here to call balls and strikes based on what the law says and not what their personal preferences are.
True. Sarah, let's look ahead now. What happens next, effectively, as a result of this ruling?
So the case has to go back down to the lower court. They have to sort through sort of all of these allegations in the indictment, what this evidence looks like, and to try to parse out what were official acts, what were unofficial acts, and what sort of falls in that middle category of official acts on the outer edge. And the court gave some guidance to the lower court of sort of how to get through this, but there really is a lot of work to be done. And the other sort of really significant thing that came out of this ruling is that the court also said that some of these activities that are official acts and cannot be viewed and for which the president has absolute immunity cannot be part of this trial at all. They cannot. That information cannot be used in evidence at this trial.
Sarah Christoph, Joe Moreno, great to get your analysis. Both, thank you very much for coming on the programme.
Thanks, Lewis.
Thank you.